Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. Imagine buying a fresh pair of wool underwear, and they make you itch so badly you end up with a full-blown skin condition. That's not just uncomfortable, it became a landmark in law. Today I'm unpacking Grant versus Australian Knitting Mills 1936. This case turned into a legal win for consumers. Here's the setup. Dr. Grant in Adelaide walks into a department store. He buys woolen underwear made by Australian knitting mills. The garment is sealed and new, nothing weird to see. He puts them on, and soon develops severe dermatitis. Doctors link the rash to the underwear. The fabric had excess sulphites from manufacturing, chemicals that should have been washed out. So what do you do when something you buy hurts you? Dr. Grant sued two parties: the retailer for selling goods not of merchantable quality, the manufacturer for negligence, failing to prevent hidden defects. Enter Donoghue versus Stevenson, the snail-in-the-bottle case. That case established the neighbor principle. You owe a duty of care to those directly affected by your actions. Donoghue involved a drink. Could that duty extend to clothing? The court said yes. On appeal to the Privy Council in 1936, the judgment confirmed two big ideas. Merchantable quality. Retailers are responsible under the Sale of Goods Act when hidden defects make items unfit for normal use. Underwear that causes dermatitis fails that test. Not safe next to skin. Negligence. Manufacturers owe consumers a duty when there's no realistic chance for an intermediate examination. Sealed garments with latent chemical residue, that's on the maker. Why this matters? Grant pushes the neighbor principle into everyday products. Manufacturers can't hide behind retailers when defects are invisible and dangerous. It strengthens the expectation that purchases must be fit for purpose, even unseen problems at the counter. Think of it as another brick in the foundation of modern consumer protection. Product safety, implied warranties, the right to goods that won't harm you. From itch to law win, Dr. Grant's case drew a clear line. If you make it for people to use, you owe them care. If you sell it as fit to wear, it needs to be safe to wear. Simple principles, big consequences. Thanks for watching. If you want more case stories that changed everyday life, hit the subscribe button, and I will see you next time.